come out of the NCAA. And why is this important? Well, number one, as most of you remember, when you played in college, and the kids that play in college today, you really don't get paid. I remember getting in a lot of debates with an ex-girlfriend's stepdad. He goes, what are you talking about? Those guys get a free college education. Well, most of the colleges brought you guys in for one thing and one thing only, and it was because you guys were really good at playing football. And if you got injured and you couldn't play football anymore, guess what? You got cut and you lost your scholarship. So you were only worth something to them so long as you could play football. Some of the guys were lucky enough to finish college, but a lot of guys couldn't. And then eventually, if you were lucky, really lucky, you got into the NFL. So that's why I think that the NCAA stuff is very important to follow. What happens to the NCAA stuff affects you. What happens to you affects the NCAA. Another thing that Shawn's going to touch briefly on is the Carl Eller lawsuit. Everybody wants to know what the heck happened. It's just kind of disappeared. And Shawn's been involved in the middle of that for quite a while. So with that, I'll introduce Shawn Stuckey. Shawn played, of course, for a few years in the NFL, went on to, you played up in the CFL, I think, for a year, didn't you? No? That's right. And then eventually Shawn ended up going up to work for a law firm up in Minnesota. So Shawn is a football player and a lawyer. So with that, I'll just make it quick and let Shawn tell you what's been going on.
Thank you, Robert. So let me start out by, well, first of all, I am counsel for the plaintiffs in one of the cases that's filed against the NCAA right now. You guys have probably heard of it. Ed O'Bannon, Oscar Robertson, both of them filed lawsuits against the NCAA. I'll go into what the substance of that lawsuit is in just a second. And then I'm also counsel for the Eller plaintiffs in Eller versus NFLPA. What used to also be Eller versus NFL. But before I talk about those two, I'm going to respond to, I don't think that Mr. Is Isaiah, is it Robertson? Okay, good. I don't think, you asked a couple of questions, and I don't think that those questions were addressed before we broke, before we took a break. But one of the questions that you asked was, is there a conflict with the NFLPA taking cases on behalf of retired players? My answer to that is no, there's not a conflict. And they could very easily do it. They could have done it in the past. In fact, some of the workers' compensation lawyers should correct me on this, but I think maybe they have filed a couple cases in the past on behalf of retired players. But the NFLPA generally stays away from litigation involving retired players because, this is my opinion, because they don't want to develop a track record of owing a fiduciary duty to the retired players. And that's really the only reason why. Back in in February, I believe, of 2011, when the lockout occurred, the current players, of course, they disbanded the union and they filed a lawsuit on behalf of all current players and rookies, and that was led by Tom Brady, Brady versus NFL, and that's what ultimately led to the 2011 CBA and the league getting started again. Well, when they did that, my law firm got together and we saw that there was a glaring omission there, and that there were no retired players who were being represented. Now, it's been the case that I believe in 2006, and when the litigation occurred with Reggie White back in, I believe, 1990s, maybe, there was not a lawsuit filed then on behalf of retired players. And I went to the NFLPA Retired Players Convention, and I spoke with D. Smith, and I told him that, hey, listen, we see that you guys have not filed a case on behalf of retired players. You know, we think there are probably some strategic reasons why you guys haven't done this, and I didn't say that to him, but I said, but I just want to let you know that our firm is going to file a case on behalf of retired players because we feel that they should be represented and they should have a voice in the table and a voice in future negotiations even after the CBA has been implemented. And Dee was very nice about it. He said, I think that's a great idea. So we moved forward. So the question begs, though, if he agreed that there was a great idea, why the NFLPA didn't do so. And again, it's because they don't, in my opinion, they don't want to develop a track record of owing a fiduciary duty to retired players. Well, I think that it's because of the threat of litigation. I mean, if they owed a fiduciary duty to retired players, then they would actually have to do something for retired players. And they couldn't just do the bare minimum, they would have to do a lot. And so because of the expenses associated with that, they then stay away from helping retired players in that respect. So anyway, when we filed that case, that actually led to, and this begins my presentation, that led to Eller versus NFL. I'm sorry, Dave.
No. I'm just,
okay.
I need to stand a little bit because of my back.
All right, that led to Eller versus NFL, and that was filed by 4 players, 4 brave players, because I spoke with a lot of retired players. I wish I had known all you guys at that time, but I spoke with a lot of retired players, and a lot of players said, no thanks. But 4 guys who stepped forward were 2 of my former teammates, a guy by the name of Obafemi Ayimbadejo. You guys probably know his brother, Brandon Ayimbadejo, who is a big advocate right now for certain rights in the NFL. And Ryan Collins, who was a non-vested player. And then also Priest Holmes and Carl Eller. So those 4 players filed a lawsuit in March of 2011, essentially trying to receive injunctive relief. It was the same thing that the current players were trying to receive at the time. Those lawsuits were consolidated. The judge put us in mediation with the current players. In fact, we were right across the table from Roger Goodell and Jerry Richardson and the other owners during the negotiations. And the negotiations started out great. We were in the room with everyone else, and then after a few days, it turned into we were in our own room, and the judge would visit us occasionally, and then the judge never visited us anymore. And so eventually, we saw that we were being cut out of the negotiations, and we recognized that the people who were cutting us out of negotiations, unbelievably, were not the NFL. It's the NFLPA. I mean, if you think about it, if you go to the, and this is just supposition on my part, but if you are trying to negotiate with the NFL and you're representing current players, and you say to the NFL, hey, listen, you give us what we want for the current players. You know, you got these guys over here who are trying to represent the retired players, and they want the moon. You know, they're saying that the retirement system is in shambles and needs to be revamped. They're saying the pension system needs to be revamped, and they're asking for billions of dollars to do it. But you know what? If you negotiate with us, we'll give it to you for a couple $100 million. But you've got to give us more for the current players. And I think that that's probably what happened. But anyway, so July 2011, we realized that that the NFL was not our nemesis, that it was in fact the NFLPA. So we sought leave to file an amended complaint. And this time we had more plaintiffs join us. Joe DeLaMele was one of them. Franco Harris was another one. Marcus Allen was another. We went on into negotiations after that, and ultimately the case was settled, and it was settled not with the best interests of the retired players in mind. In fact, it cut out the retired players in large part. So We filed another lawsuit in October of 2011. We voluntarily dismissed our lawsuit against the NFL, and we filed another lawsuit against the NFLPA. Joe DeLaMalle, Paul Krause, Chuck Bednarik, Carl Eller. I could go through the list of the other guys, but it was a lot of guys. It was 27 Hall of Famers who filed this next class action. And essentially, and the claims in that class action were breach of fiduciary duty on behalf of the Players Association, intentional interference with prospective business relationships, and a declaratory relief. That case, the NFLPA filed a motion to dismiss. That case was ultimately dismissed in May of 2012. And essentially what the judge said was, these guys were negotiating their own contract. And if in doing so, they compromised the rights of retired players, well, that's just part of the game. Although the NFLPA maintained all along that, hey, we never did anything with retired players. We never even spoke about retired players in this case. They maintained that throughout the entire, throughout the motion to dismiss process. Their claim was undermined heavily because they submitted a document in December of 2011, and attached to that document was the Brady Settlement Agreement. And for the first time, the Brady Settlement Agreement became public. And my opinion is that they didn't mean to submit this Brady Settlement Agreement. They did it. They submitted it as an attachment, and they meant to submit it under seal, but they didn't. It was publicly available at that point. And as part of that Brady Settlement Agreement was a legacy fund. And so the reason it undermined their arguments is because if you're saying that you're not negotiating anything on behalf of retired players, and here is this legacy fund that was agreed to before the CBA ever began, then obviously you were negotiating on behalf of retired players. So anyway, we filed an appeal, and that was a big part of our appeal. We are essentially there are multiple instances where that demonstrate that the NFLPA represented or negotiated on behalf of retired players. Multiple instances, but they're claiming that they didn't do anything on behalf of retired players. They didn't discuss retired players during the CBA negotiations. They didn't discuss them afterwards. The only time that retired players were ever discussed is after the Brady Settlement Agreement was agreed to, and the union collectively bargained that for the players. But it's just not true. So anyway, that case right now is on appeal. All the briefing has been submitted, and we are now awaiting oral argument. And what's at stake for you guys, for all retired players, is we feel that there was at least $1.5 billion that was left on the table for retired players. We come to that number because the owners offered $500 million to the players, $50 million per year for 10 years. And then it was very well known at the beginning that the owners wanted to decrease the amount that rookies were going to be making. They thought that rookie salaries were just getting out of control. So they wanted to impose a rookie salary cap. And with the savings of that rookie salary cap, they were going to split them between the free agents and the retired players. And so the rookie salary cap would have yielded $300 million per year in savings, which would have been $3 billion over a 10-year period. And if you cut that down the middle, that's $1.5 billion right there. So really, optimally, you're looking at $2 billion that was left on the table. But let's say that was going to be a 30% cut for retired players, not 50-50. So then you take $1 billion of that, and then the $500 million that was supposed to go from the owners, and you come to $1.5 billion. And that's what is at stake with the Eller litigation. If the court finds in our favor, that $1.5 billion will then be turned over to retired players in the form of increased pensions, significantly increase pensions and other programs, but really the main part of that will be increased pensions. So that's what we're hoping for. Second case is the NCAA case.
What's your schedule for the Eller case?
Like I said, we've done all the briefing for that, and we're waiting for the court to give us an oral argument date. Once the court gives us an oral argument date, which I'm assuming will probably be sometime in June, the court will take it under advisement. I mean, they may rule from the bench, but probably they'll take it under advisement, and then anywhere from 30 days to 90 days after that, we'll probably get a decision.
Shawn, let me ask you, what about disability? Is it going to deal with the disability issues at all?
It is. That I can't remember all of the claims that we asserted, and all the various damages that we asserted, but that is certainly a part of it. It will be increased, not only increased disability payments, but hopefully it will change some, and I don't know if this particular lawsuit can do it initially, or if it will somehow lay the groundwork for it, but we hope to be able to change some of the rules associated with disability that have thus far limited players from obtaining the benefits that they should have received.
Sounds good.
Sure, absolutely. Any questions? Well, I knew that there were conditions associated with the money, but in public statements that the owners made, particularly I'm referring to a letter that was written to the retired players that many of you probably received. When they wrote that letter to retired players, they said, we recognize that retired players have not been treated the way they should be treated. We want to change that. This is what we are offering to retired players. They didn't put in that letter, this is what we want to return, but I'm sure that there were conditions to that $500 million. Right. Well, yeah, but the thing is, as it stands right now, if this case, if we went on appeal and we go back and we're able to adjudicate this case, he'll have the opportunity, the owners will have the opportunity to defend that letter. But on face value, if this, hopefully were to ever get in front of a jury, the jury is going to read what that letter says. And they can come in and say, well, it was dependent upon, it was contingent upon this thing and this thing, this thing. But in that letter is pretty clear. And if they wanted to make it contingent upon something, they could have put it in the four corners of that letter, and they didn't. So. Do you have any idea how that would actually work when you've already received the $930 million from the owners already that the PA has in the bank account? Yeah. Well, that's one of the hurdles that we'll have to overcome. We're going to have to convince the judge that we don't have to go back through and dismantle the entire CBA. We think really you can just look at the money that the NFLPA received. The NFLPA should have that money in its bank account. If they don't have the money in the bank account, they can come up with it from somewhere. And if optimally the judge says, hey, these guys should have been given $1.5 billion. You only got them $600 million or $900 million. You owe them the difference, or actually, you owe them all of it if you can't prove that they received the remainder of it. So that's where that money will come from.
But it will come from the PA, not the NFL?
Correct.
Do they have the resources?
The PA? Robert can probably answer this question better than us because he sent out a...
Yeah, and in answer to your question, he's laughing because they do. And see, one of the problems we have here, no one gives us any information, okay? Where's our union? They should be representing us. They're not here. And there's different lawsuits. And when we have head injuries, we mix up our lawsuits. And, you know, this is totally different than the concussion. So take the concussions and just put that in one bucket. Okay, this is another one, and there's 3 other ones. Okay, so in answer to your question, they have the money, they just don't want to give it up.
Yeah, but they have $300 million of that. The other 630 has already been assigned. So say, for example, I made $1,400 on the legacy fund. My wife got 25%, left me with $875. So how can you come back and take that from me?
No. They won't be taking any money from you. What they'll do is, if that $600 million has already been paid out, which it hasn't been paid out yet. I mean, I don't know the exact amount that's been paid out, but let's say $100 million of that has been paid out. Then they take the $500 million that hasn't been paid out from the NFLPA, and they distribute that. It's still coming back to you. I mean, the amount of money that you've received thus far is money that you were entitled to, and money that will never be touched. The only thing that can happen is that you will receive more money on top of that. It'll never go down.
So you're saying to me that the people they all pension plan in where they put that money, that's to come out of that money? In order to be able to facilitate what you're saying?
Well, this is really the same thing.
Or you all want to start another pension with the money you make?
No, it will. I mean, theoretically, it could go through the same pension plan that's set up, and it would. You just take that. Let's say out of the 1.5 billion, there's an additional 200 million on top of the 600 million already that should go to pensions, and they would just take that $200 million and they'll put it in the Burt Bell, Pete Rozelle, in the pension plan that exists right now, and then it will result in. If you're making $2,000 a month right now in pension, it'll result in $3,000 a month or $4,000 a month. It's they're just taking that money and giving it to you guys. Really, what it's doing is coming from the PA. Any money that they have not already assigned to you in some manner, and it's forcing them to compensate you for what you should have gotten. The NCAA case. The NCAA case is brought on behalf of, and most people don't understand, I'm sure many of you have heard about the NCAA being sued for the use of players' images. What most of you probably don't know is the NCAA or included in that class of players is not only current players, but former players. And it's not just former players who played a few years ago, it's former players who played all the way back. So that's one of the reasons that Oscar Robertson and I'm not thinking of his name right now, but that's one of the reasons that they are the class representatives in this class, because it will go all the way back. The constraint is, because of the statute of limitations, you can only look at images that were shown from 2005 to the present. But if there were a situation where any of your images were shown anywhere from 2005 to the present, there's going to be damages involved that may ultimately be returned to you, or that you may ultimately be compensated for. And so to give you guys a more specific explanation of what this is, the plaintiffs are suing the NCAA alleging the defendants participated. Well, first of all, there are two portions of this case. You've got a publicity rights portion of the case, and you've got an antitrust portion of the case. The publicity rights portion of the case has been stayed thus far. So right now, the antitrust portion of the case is pursuing, and this is what this is a description of the antitrust portion of the case. The plaintiffs are suing the NCAA alleging the defendants participated in a multifaceted conspiracy and violated antitrust law by conspiring to fix at zero the amount of compensation athletes can receive for the use of their names, images, and likeness in products or media while they are in school or long after they cease attending intercollegiate athletic competition. More specifically, the plaintiffs allege that the NCAA, its member schools and conferences, CLC, and EA Sports violated Section 1 of the Sherman Act by organizing a horizontal cartel and engaging in a price-fixing conspiracy and a group boycott to limit the student-athletes' compensation. Additionally, the plaintiffs allege that the NCAA improperly requires all student-athletes to sign forms each year which purport to require them to relinquish all rights in perpetuity to the commercial use of their images even after they graduate and are no longer subject to NCAA regulations. The plaintiffs also have claims for unjust enrichment and accounting. So essentially what that's saying is that the NCAA conspired with other co-defendants to not compensate players while they are in school, and for the players when they leave to not compensate those players either. We had an expert go through and value the damages. I can't remember off the top of my head what the damages are, but let's say $50 million per year, and this would be for the current players, $50 million per year for the SEC, for example. They determined that the SEC has been using these players' images and they owe current players $50 million per year. So what theoretically could happen with the current players is they would take that money, that $50 million, and they would put it in some sort of a trust fund for these players. So after they're finished playing their 4 years of college, they then have the ability to use this money in their trust fund to, say, go and work on their master's or complete their degree. With regard to retired players, what it does is, number one, it sets up an injunction to prevent them from doing this in the future, but it also, I can't remember the amount of damages that retired players have, but it then takes that money and it puts it in a pool for retired players. So theoretically down the road, I don't know if it would result in individual checks going to retired players like the EA settlement did, but it may result in a sort of a fund established where retired players can submit various declarations and then receive money from that fund. So anyway, there's a chance for recovery under the Eller lawsuit, and I'm actually pretty optimistic about the fact that that case is going to be overturned on appeal. And if it is, that's going to be a lot of fun for you guys, because when we go into discovery, you're going to be able to get a lot of documents at the end that the NFLPA does not want you to get, and hopefully it result in a good settlement. And the NCAA case can potentially result in some sort of a settlement for retired players as well. That's all the questions I have. Or I mean, those are all the statements that I need to make right now. Any questions?
Be careful how you use that word settle. Because so far, these settlements have not settled in our direction.
I think I know what you're talking about, and I agree with you. I agree.
Well, Shawn, I'd like to thank you for sharing information about what's really going on. So I really appreciate it. Thank you.
Boom 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 boom